In the DeMarco case, we see an example of the change in the law from the common law view of duress to the model penal code view of duress. When you read the Markman case, you're also going to see that the common law did not allow the claim of duress if the crime that the defendant committed was one of first-degree murder. The model penal code, which Pennsylvania has adopted for duress, allows a claim of duress for even first-degree murder. And again, the jury has to decide whether a person of reasonable firmness would have felt coerced into committing that act. So it's not a win. You can't just merely claim I was coerced or even show coercion. It has to be that a person of reasonable firmness would have felt no choice but to commit the act in question. And so that would feel different if it's first-degree murder or if it's shoplifting. But in any event, we're looking now at the DeMarco case, where we see that the difference between the common law and the model penal code is in the type of force that has to be claimed before you are allowed to get the instruction. So if under the common law you were threatened with either death or serious bodily injury, you could bring a claim of duress with everything except regard to first-degree murder. In the model penal code interpretation, however, you don't have to meet that threshold requirement to get this question to the jury. If the threat of, or the coercive threat is anything, any act of unlawful force, I will beat you up if you don't do this, then your case will get to the jury. And the question will be whether whether a person of reasonable firmness, or whether you, as an individual, as we learn in the DeMarco case, with the particular mental frailties that this particular defendant has, felt coerced under these circumstances such that he, in that boat, would have felt like he didn't have a choice but to, in this case, lie. The allegation here is certainly not first-degree murder. It's, would you commit perjury when you were faced with the types of threats the defendant was faced with? Under the model penal code and under the interpretation of the lower court, because there was no threat of serious bodily injury or death, the defendant doesn't get to make the claim of duress. However, the Supreme Court said the lower court got it wrong. The lower court was following the old common law test, and that's where those elements came from. And those elements that the lower court was using track the common law, not the model penal code. The model penal code has no requirement of serious bodily injury or death as the coercive threat. That any threat will do, that will get you to the jury, so long as you didn't recklessly place yourself in the position that you could have been coerced. And again, that's going to be a question for the jury, unless it's just absolutely clear to anyone who looks at it that either there was no coercion here, there was no coercive threat, or that the defendant very clearly was reckless in placing himself or herself in a position that he or she knew he or she would face this type of coercion. We talked about in the Markman case, if you join the Hells Angels and they threaten to beat you up or kill you if you don't commit certain unlawful acts, you could see that coming. You were reckless in placing yourself in a position where that kind of coercive threat would be put upon you. But the story with DeMarco is one or the question in DeMarco is the elements that apply to a claim of duress as a defense, and under the model penal code that Pennsylvania has adopted, any type of coercion will get you to the jury. And the question for the jury is, given the amount of coercion that you faced, given your particular frailties, do we believe you were left essentially without a choice?